May it please the court, Attorney Jacqueline Palumbo on behalf of the appellant, Brian Dennis, we would request 3 minutes for rebuttal in this case if the prosecutor.
I was just going to say, I should have explained, I apologize. I guess at this point, they have not waived, so whenever they come in, they can argue after you're done, or if they do not appear, then we'll just go ahead and allow you to finish your argument. Okay? Thank you. And I'll know that you want 15 minutes for 3 minutes. You want 15 minutes. Okay, 3 minutes for rebuttal. Go ahead now. Counsel, thank you.
I am relying on my brief for assignments of error 3 and 4 discussing hearsay in the Sixth Amendment, and will proceed on assignments of error 1 and 2 together for purposes of organization regarding standing and the expectation of privacy in this case. The issue in this case was should the trial court have found that Mr. Dennis had a reasonable expectation of privacy and standing to challenge the illegal search and seizure, and should the trial court have granted the motion to suppress, the answer is yes. The standard of review in this case is de novo because this is a review of a conclusion of law by the trial court. Our position is Mr. Dennis had standing to challenge the illegal search and seizure based on the reasonable expectation of privacy he had in the home. The state's position in this case is that because the homeowner consented to a search of the home, that the search was legal. However, this is not correct. Based on the case of Minnesota v. Olson, my client had a reasonable expectation of privacy and therefore had standing to challenge a search. And based on the cases of Wong, Son, State of Ohio v. Carter, referencing Nardone and Katz, the search and any evidence obtained was fruit of the poisonous tree and must be excluded in this case. We will be requesting this court to reverse the decision of the trial court as to the motion to suppress, exclude all tainted evidence, and order a new trial.
So what was the evidence that the evidence was that he had stayed there for a week and a half?
Yes.
Okay. And the homeowner or the renter or whoever it was did not appear to testify?
Correct. Police need probable cause and a warrant, or probable cause and a warrantless exception in order to conduct a search. If the state fails to satisfy either step, the evidence seized and a reasonable search must be suppressed according to Mapp v. Ohio. When officers are not responding to an emergency, there must be compelling reasons to justify the absence of a search warrant, pursuant to McDonald v. United States. In order to have standing grounds to challenge the search, a person must have a reasonable expectation of privacy in the area to be searched. A reasonable expectation of privacy is one that society is prepared to recognize as reasonable in weighing the privacy of the individual, subjective and objective grounds, and did the defendant think he had a privacy interest, versus a legitimate governmental interest. Pursuant to Minnesota v. Olson, the court determined that overnight guests have the same reasonable expectation of privacy where they are staying as a homeowner. In the facts of that case, Mr. Olson was staying in an upper duplex unit. Officers entered with guns drawn, arrested him, and he later made an inculpatory statement. He was alleged to have robbed an Amoco gas station, may have been the getaway driver, and it was not his duplex. He was later found in a closet. In the analysis of that case, the court looked to Jones, Rackus, and Katz to determine whether or not society recognized as reasonable the same expectation of privacy as a homeowner, as a house guest.
Are we going to find in the record any evidence regarding your client's belongings, overnight bag, suitcase, anything?
There was nothing in the record regarding that. From the overnight guest perspective, as the court determined, he seeks shelter in another's home precisely because it provides him with privacy, a place where he and his possessions will not be disturbed by anyone but his host, and those his host allows inside. However, in this case, although he had no belongings present, or there's nothing in the record that indicates that he did not have any belongings, merely his presence as an overnight guest indicates that he has the same expectation of privacy as the homeowner based on being cloaked in the same privacy as the homeowner in this case.
Now, if we determine, I'm sorry.
No, go ahead.
That consent was given by the homeowner, we need not consider this part of your argument, correct?
I would say that the argument still needs to be considered based on the fact that he was an overnight guest in the home for approximately a week and a half.
So even if the homeowner invited the police in and said, you're free to search the room that he's in, you would still maintain that he has privacy?
Yes.
As an overnight.
Yes.
And also in your brief, you made reference to the allegation that the homeowner was, I think the exact language that you used, was coerced into allowing the police to come in. and did not give consent. The police officers testified, or at least one of them testified, that your client didn't even know that they were there. He was back in the back room. So from what perspective can he say what happened at the front door when the police came?
From the testimony that my client gave, he had stated that he could still overhear what was occurring even though the TV was playing in the background. So the police officers were saying he was in the back bedroom, but I believe the square footage of the house was approximately 982 square feet. And he had stated that he could still hear the police radios, he turned the TV down, and therefore he could hear what was occurring
I see.
outside the bedroom at the time.
Thank you.
And at all times, that bedroom door was open?
Correct. In addition, the homeowner had requested that the officers get a warrant at the time. The state's position and my position, the characterization of the facts are substantially different. However, they did, at that point, make entrance to the home, which is what the police report had indicated that the officer testified to, is that they made entrance to the home. The officer testified to the fact that the homeowner had requested that they go get a warrant, and they did not do so at that point, but they were made aware at that point. Then they made entrance, at which point she said, you know, I'm going to go get him from the back. And they said, no, you stay here, we'll go get him. So at that point, she wasn't really free to move about the home. They entered, asked, with guns drawn, ordered Mr. Dennis to stand. At that point, then they see the gun, arrest him, take him out of the house.
Let me ask you a question. The state indicates in their brief that he stated that he either stayed at the house, he either slept in the bedroom or on the couch.
Yes.
And he did not have a room.
That,
So how does that indicate a reasonable expectation of privacy? If you're just staying wherever, sometimes on the couch in the middle of everybody, and you don't have an assigned room?
I would say that based on Minnesota v. Olson, at the time he was sleeping in the room or he was sleeping on the couch, where the police found him at the time he was in the room at the time of the search.
Well, what was the indication that he actually slept in that room? He said he wasn't assigned a room. He didn't have a room to sleep in that was his. And then you also indicate there's nothing in the record that indicates any of his belongings, like a suitcase or any of his personal belongings. For instance, you know, obviously a stronger case would be there's a back bedroom and he says that's where I sleep, and you find his suitcase there, you have clothes hanging in the closet, those type of things. But we don't have any of that here, do we?
No, we don't, and I think that's based on the client's testimony that he had just recently split from his girlfriend, and they were giving him a place to stay for about a week and a half. And I think it goes to the fact that maybe in some, you know, middle class or upper class circumstances, we wouldn't necessarily expect that they would have, you would have to see belongings hanging up neatly and nicely in a closet, in a suitcase.
Well, you wouldn't see that in my house either, neatly hung up in a closet. But my point is, to see something, even if it's strewn across the floor, that I live there.
I don't believe the record reflects that police looked for anything of that nature, and the person that could have testified to that was Autumn Clark, and she didn't appear for trial.
Whose burden was it to show that he had a reasonable expectation of privacy? Was that the state's or was that his?
That was his burden. And I think at that point, he didn't have an opportunity to go back and maybe collect additional evidence or anything at that time, because he had been arrested at that point and taken into police custody. He didn't have any further contact with Autumn Clark after that point. I believe he stated that he'd spoken to her only once after that. I'm sure based on the fact that he had been arrested at that point. Now, based on the argument that he had a reasonable expectation of privacy in the case based on Minnesota v. Olson, that gives our client standing to challenge the search in this case. And there were 5 points of contact from police in this case. There was the illegal entry into the bedroom. They ordered him to stand up with guns drawn. They see the gun. They arrest the defendant. Officer Eller escorts him out of the house, asks him if he has drugs at this point, makes a statement, yes, there is cocaine. They find cocaine in his pocket. Based on that arrest, they then impound the car and find heroin in the vehicle. There was nothing sufficient to break the taint of the illegal conduct of police in this case, and all evidence, the gun, the cocaine, and the heroin, must be thrown out based on the fact that he had a reasonable expectation of privacy and there was no warrant or a justifiable reason to not have a warrant when they entered. Based on Wong's son, it stands for the proposition that if the taint of legal conduct is dissipated from police, new evidence may be admitted because it is no longer derivative of that illegality. Our argument is that all of these points of contact with police happened in such close proximity in sequential order that there was nothing sufficient to break the taint of the illegal conduct of the police. So even though he had cocaine in his pocket and there was heroin in the car, based on the illegal entry into the bedroom and the seizure of the gun at that point, that started the domino effect, if you will, for fruit of the poisonous tree in this case.
What was the third thing you said, the guns, heroin, and something else needed to be thrown out?
The cocaine in his pocket. I believe it was in the watch pocket of his jeans. So, you know, if, for example, the officers had gotten a warrant and proceeded into the home with the warrant, this would be a very different case because he did have cocaine on his person. I mean, but in this case, because of the Fourth Amendment, they had to get a warrant or have a warrantless exception in this case. And we would argue that there was no warrantless exception for them to enter the home. And since they weren't responding to emergency, there was no screaming voices, there was nothing to indicate that the police should enter. The car was parked outside, it was back into the driveway. They'd already had officers circling around back to see if anybody had fled the home. Mr. Dennis was in a sitting position in the back bedroom. There was nothing indicating flight or a safety risk at that point that would justify a warrantless entry into that back bedroom.
You're just about 3:50. I don't know if you want to address your other assignments of error quickly.
Not at this point. I would rest on my brief for those assignments of error, and at this point I would just reserve 3 minutes for rebuttal to address any arguments made by the prosecutor.
Thank you.
May it please the court, my name is Rachel Richardson, Assistant Prosecutor on behalf of the state. The case before us today is in regards to Mr. Dennis, who was merely staying in a woman's home with a stolen vehicle in the driveway and drugs on his person, a gun on his person, and more drugs in the car. Justifiably so, he's upset that these items were taken from him and that he was seen in the home when the homeowner consented to the search. One of the issues brought up repeatedly here is whether or not he was a house guest in the home. I believe we can just turn to the testimony of the officer, since the homeowner didn't testify herself in this case, where the officer says, "Who do you stay here with? Are you the homeowner?" She says, "I'm the homeowner with my children." She doesn't say that Mr. Dennis is one of the people in the home, but she says, "Yes, the man driving the car is here and he's in the back bedroom." She doesn't say, "Yes, he's in his room. Yes, he's staying with me and he's a house guest. Yes, he's paying rent. Yes, he's living with me. You'll need to ask him." I mean, she did say you need a warrant, but changed her mind when she realized that this would be a bigger issue for her, and really she's not the one in trouble here.
How is that not coercion on the part of the police? When they come and knock on the door and ask if they can come in, and she says you can come in if you have a warrant, and then they say, well, you know, you want to get in this, basically. How is that not coercion?
It's the matter of, it was determined by the judge she was in the best position to make that decision because it's a factual-based question. And at that point, they determined that it was a good decision for her to make. It made sense. She didn't think about it at first. She thought, first, protect my home. I don't want someone in my home. But when she realized that it could impact her and her children, and she really wasn't the one that they were after, it was a different situation. It was just a matter of explaining to her, we're not interested in you.
Let me interrupt you for a second to follow up on Judge Moore's question. The fact that it was a good decision for somebody to make doesn't mean that it's not coerced. I can, technically, I'm allowed to, by law, force my children into making what I consider to be the best decision for them.
Sure.
That still doesn't mean that that was made of their own free will, just because it ultimately was maybe the best decision for them to make under the circumstances.
Well, Your Honor, I would say that this isn't the scenario where the officers were threatening her, screaming at her, demanding she open the door, demanding that, you know, if you don't do this, I'm going to arrest you right now. There was no immediate threat to her if she didn't do it. I'm sure they're not wanting her to stay in the home with where they believe that she just admitted there's a suspect in the home who has stolen a vehicle, is in the home with her. They're not comfortable leaving at that point. Asking a second follow-up question, and kind of encouraging her to do the right thing is kind of their job too as peacemakers in the community. They're not supposed to just take no and walk away, particularly when, her rights aren't really being violated here. It's not her, it's her right and she's giving it up. She's volunteering for them to enter her home. She's okay with it. She's accepting it. And there's nothing really to the contrary of that except for Mr. Dennis, who claims that he knew the officers were there and he knew that she was not going to let them in or she didn't want to let them in. That's more concerning, I think, to hear that Mr. Dennis heard the whole conversation and still had a gun in broad daylight, broad view for the officers when they entered the home. That's very concerning, I think, for
Now, what did she
the
say
parties.
whenever the officer said, you don't want to get involved in this or something like, in this mess?
I believe at that time she offered to go get him for them,
That's right.
and they told her that that was a risk. And of course that would be. Now the officers have encouraged her to go into the back room. I mean, that this could become a hostage situation. This could be, you never know really what will happen, especially in a domestic situation.
I understand that. I guess I'm looking for, though, when they said you don't want to get involved in this mess, and I can go back and look. I'm trying to remember if she said, she just replied, I can go get him, and then they just walked past her, or
She said, okay,
she said, okay, is that what? I couldn't remember what she
on
said.
page 5 of the Council 3.
Okay. So you agree that's what the testimony was?
She did, they said that to some extent they just felt comfortable to enter, that she no longer was blocking the doorway, that it was very easy to pass by her. She, of course, wasn't happy about it, but it wasn't a matter where they weren't permitted in the home. I think at any point that you have someone entering your home, you're not necessarily excited about it. It's not the typical consent situation where you're like, yes, please, as a house guest, come into my home. She knows the situation isn't going to turn out well. A friend of hers is going to get arrested. She's not happy about it, and that's understandable, but the legality here is that she permitted them into the home. It was her right to be able to consent to that. Whether or not her consent was happily done, I think that's definitely not happy consent. She didn't like to do it, but she did
Well, the
it.
court never determined that the consent was voluntary.
The court determined the consent was voluntary based on the testimony of the officers because the homeowner wasn't present to testify to it. The only testimony we had based at the suppression hearing was the officers who testified and presented how they entered the home and why they entered the home.
Opposing counsel indicated that the defendant testified, said that he could hear it and that she did not give consent. So I imagine that would go to
Sure.
the court making a credibility determination.
Well, and the court determined that they felt that the defendant was too far away to be able to hear it, that his self-serving testimony about whether or not she allowed them into the home didn't seem realistic, especially when he's sitting there with a gun right there in the center of his, in front of him, knowing that the officers are coming in the home. It doesn't seem realistic. He might say he got up and turned the television down, but, she says he didn't know they were coming. I mean, everyone seems to indicate that he was caught totally off surprise when they entered the room. That's the testimony of the officers, that he seems totally caught off guard. I mean, it's not like he shut the door for them to not be able to enter and knock and enter into his area. And there's no testimony that it is his area. He himself says, I sometimes stay here, I sometimes stay there. And having a fight with a significant other means that you might not stay there all the time because some days you get along with them, some days you don't. And that seems to be the indication here, is that sometimes he stays there. I think the court referred to it as a flop house. It wasn't necessarily where he stayed, but he might stay there and hang out for a little while. Doesn't even know the children's names, where these people he says are his friends and he's staying with for up to a weekend. And I'd imagine in a house with small children that you would, or they would make sure you know, to some extent, your name or their name, that it's not something that goes unnoticed in a home having small children. Sure that the homeowner resisted to some extent. She didn't want them in her home, but she did consent ultimately to the entry into the home. The only testimony to the contrary to that is Mr. Dennis, who offered self-serving testimony saying that he didn't think that they had a right to be in the home. He never says, though, that they didn't ask me if they could enter the bedroom. Well, he left the door wide open in the bedroom, and he didn't say, stop, don't come in. He asks why he's being arrested, and of course, at that point, they let him know, well, you have a gun right here, and we need to talk to you, and we believe that you're a suspect in this stolen vehicle outside. I mean, it's not as though it's not as though the police officers just entered a random home, asked the homeowner if they could come in and search. There was some triggering factor, that being a car that was stolen in the driveway. And what they really ask is the person who drove the car here? They don't enter the home and say, can we search your house for everything that's in it and try and get you in trouble? No, they say, can we come in and find the person who has a stolen vehicle? Do you want someone with a stolen vehicle in the home?
By the same token, at that point, all they had was a stolen vehicle. They didn't have, as counsel has pointed out, any evidence of any violence, any screaming, any threats, anything like that. Could just as easily have gotten a warrant.
Sure.
Especially where the homeowner says, when they ask to enter, do you have a warrant?
In hindsight, it would have been much easier for all of us had they done that. However, I don't think that the facts are such that constitutional rights were violated by not getting a warrant. Asking the homeowner twice, really, if they can come inside to arrest someone who is just a different method of obtaining the same result. Getting the warrant would be a little bit safer and easier to check because we have a second party checking it. However, in this situation, the officers felt as though that they needed to take action. They know that this vehicle had been driven recently. They followed it to this house, and they asked the homeowner if the person's there, and they say yes. I'm sure at that point they're also concerned, well, what if we leave, if we wait, what's the next step? It's like a rolling ball. It got started and they just finished it through. They saw it through. And they did ask 2 questions, but I don't believe that the questions they asked demonstrate that she didn't consent to the search. She didn't like the search, but I don't believe that she didn't consent to it.
And so your argument, though, is in regard to the defendant, so I'll make sure I understand, is that he did not have standing to assert any of this anyway.
Absolutely
Is that
not.
what you're saying?
Yes.
And that is because he did not demonstrate or did not prove that he had a reasonable expectation of privacy at the suppression hearing.
Exactly. Thank you. Very well said.
No, I'm just trying to figure it out to make sure
Right.
I'm on the same page with everybody.
Yes, he doesn't have a reasonable expectation of privacy. He's just merely a person staying at the home. He doesn't exceed to the level of a house guest. He didn't even have a general place of staying. He hangs out there, and this court has looked at that before, where a party is not a house guest but merely staying in a home and realize that they don't have the right to assert their constitutional rights in search and seizure situations because they don't have a property interest. They don't have an interest in the home.
I understand that there was no evidence in regard to his belongings. The defense did not present any evidence in regard to that, nor did the police testify to that, correct?
Correct.
I don't know that I'm overly concerned over the fact that he didn't know the kids' names. I mean, that happens. I don't know that that's demonstrative of whether or not he, had permission to stay there and was staying there. What else? He said that he was, sometimes stayed on the couch, sometimes stayed in the room.
There's no indication he had a key. There's no indication that he had belongings he kept there on a regular basis. I mean, and I'm sure that the officers would have searched that if that would have been there, because they searched everything else of him. They searched his person. They searched, the vehicle that was tied to
It's not
him.
necessary to have a key to be a house guest.
Right. But it's not helping anything that he doesn't have a way to come and go as he pleases as a house guest either. It's merely that he comes and he sometimes stays here or there. There's no set place, there's no set plan for him to be there, there's no set plan for him to be a guest. It's just that sometimes he stays there, and that's kind of the way he even put it himself. I stay there sometimes. It's not that this is where I'm living. It's not that this is where I'm staying, this is where I eat, this is where I sleep, this is where I live. It's sometimes I hang out here. And I think that his casual nature to it and the fact that she's very casual about it as well was best determined by the court, who was able to judge his personality about it, his demeanor about it, the way he explained why he lived there and the way he lived there. And the facts of the situation seemed to be that this wasn't a place that he stayed. Sure, he might have had a fight with his girlfriend, but there's nothing to demonstrate I mean, that's just his testimony. We don't know if that's even true, that he had a fight with his girlfriend, he stayed at that place. It's that he says he's staying here sometimes. I mean, he didn't bring in his girlfriend to testify that she kicked him out and he's living here. He didn't present any evidence to the contrary that he has another residence and this is just a place he stays, and to say, this is how long I've been staying here. He brought no evidence in to suggest that he stayed there other than his own self-serving testimony. And
His testimony is self-serving and the officer's is not.
the officer is presenting testimony as part of his job description. It's just explaining what he did as a day-to-day basis. So it's not something that we would believe he would lie about because he doesn't necessarily have the same benefits that would come out of it. It's not as though the officer, really, if the officer was going to lie about it, I think he could have lied better. He could have told the story in a much better fashion. It's the situation where one party doesn't want to get in trouble, who's kind of busted with a lot of stuff going on, trying to come up grasping at straws for something now, versus an officer who's telling a situation and explaining the story as it panned out, as the reality happened, and trying to be as truthful as possible.
Well, that's certainly one perspective, but another perspective is that the officer may have violated someone's constitutional right to be secure in their home and has an interest in protecting that entrance by saying that, well, yeah, she voluntarily let us in, when in fact, she was stolen. I'm not saying that she was, I'm saying that's another perspective.
Sure. And to the contrary, that I think what would have to happen is Mr. Dennis would have to have her come to testify on his behalf, really on her own behalf, and assert that her rights were violated, and then conversely, his rights were violated. But absent that, I don't think he's met his burden of showing, I mean, she didn't come. She didn't obviously have enough of an issue with it to come to the hearing. We can't make her come to the hearing, to a suppression hearing. It's not the burden of the state, it's not the burden of the officers to make sure that she comes in. The officers are there telling the story as the way that they saw it occur, and that's the point of having a hearing, is to have both sides be able to present their material. And that's what happened here, and unfortunately, there wasn't anything to counter that argument. So the court didn't really have anything else to rely on to balance that out, other than just a general suspicion of officer behavior. And that's not really something that's supposed to be brought to the table. It's reviewing the facts that are before the court.
And you're out of time, so
Thank you.
you have about 3 minutes.
Thank you.
In regards to Judge Moore's question regarding whether or not the homeowner was coerced by police, I would ask the court to turn to suppression transcript pages 10 and 16. The attorney had asked, you said you needed to talk to him, and she said, okay. The officer responds, yes. She said, yes, said, all right, something along those lines. I can't say she said, okay. All right, or something like that. And if you look to page 16, when they say, when the question is, so she tells you that you're not coming in without a warrant, you say don't get mixed up in this mess or don't get caught up in this mess. He says correct, and they say, what does that mean? And he says, that means don't get yourself in trouble with somebody else's problem that came to your house, meaning you have the possibility of being arrested. We would argue that's coercion. Our point 2 is that Dennis was acquitted of the receiving stolen property charge and the vehicle wasn't stolen. Thirdly, no one asked the police officer if the officer had searched for evidence of living arrangements or anything of that nature. So that, I would say, is not in the record and not in evidence. To assume that the officer would have searched the area to justify his search after he believes he already has consent to search is counterintuitive. He didn't have to search for evidence of living arrangements in his mind because he already had in his eyes consent to search. They arrested him and escorted him out, and that's all we have in the record. We don't have that he did an additional search of the home to justify whether or not their search was legal at the time. They were concerned with, as the prosecutor states, the arrest, trying to protect the community. And that's definitely very much appreciated in this community. However, it still violates the rights of Mr. Dennis. He did indicate he had been staying there for a week and a half. He didn't say he'd stayed there sometimes. He'd said, I've been staying there a week and a half. And in addition, the argument that Mr. Dennis could be self-serving goes to Judge Moore's point that, in addition, police officers could be giving self-serving statements as well, assuming they want to protect their job, protect the search that they conducted, that they believed at the time they had consent for. And thank you.
Thank you. The court will take the matter under advisement and will issue a written opinion that will be sent to both sides, as well as we will release on our website and Supreme Court website.